I forgot to do the grift. Guys, click the fucking like button.
By the way, folks, I want to make very clear, please don't go to Natalie's Twitter timeline and give her shit about this.
No.
I don't want anything like that. That's not what we're here for. I'm just here to give kind of my perspective of this interaction. Definitely no dog piling on Natalie. I've seen her real world photos. She has enough to deal with as it is.
Let me set this stage, I suppose. You are Andrew Branca. You're a humble self-defense merchant. You're out here talking about doing case analyses for the public just for whatever, just because that's what you do. You do analysis of cases, and then occasionally you get hired to consult on actual cases that involve the use of force in self-defense capacities. That's your specialty. And there are not too many people who have the kind of qualification expertise that you do in this field. Is that accurate?
To my knowledge, I'm the only one in the country.
And so when people get involved in a self-defense situation in any of the states or in federal court or whatever, sometimes they will call you up and say, hey, I would like you to consult on my case, please. And help my team construct an argument for the justified use of force, right? Is that accurate too?
When you say they call me, I should make clear, it's the attorney that calls me.
Is that what it is?
Calls me. Right.
So you're saying, no, I don't believe this. So you're saying that someone's attorney calls you, not the client themselves who calls you without the knowledge of their attorney.
Right, because that would be unethical. Because if they've retained counsel, I'm not going to interfere with that attorney-client relationship by speaking directly with the client. I would speak with their attorney, which is the appropriate avenue of communication. And if they don't have a lawyer, the first thing I would tell them is get yourself a damn lawyer, because I don't take clients directly. Even if they were in Massachusetts, which is the one state where I'm a member of the bar, I would not take them as a client directly. They need to retain local counsel as their lead counsel on the case and have their lawyer call me.
So you're saying that in 100% of the cases where you consult with a legal team, that the lawyer on that legal team has consented to your consultation and actually even is the one who has hired you?
Indeed, the check comes from the lawyer.
No.
Yeah.
Mr. Branca, that is ridiculous.
In fact, I would say in 9 out of 10 cases, I never speak to the client at all.
But what about those cases that you provide analysis for on the internet? Is that unethical? I mean, an attorney commenting publicly on a case that they're not associated with, it seems like there could be ethical problems there.
Yeah, only a very stupid person would think that.
Oh no. Should we get, do you have these tweets? Like, do you,
I have a few.
What is this? You're blocked?
So I'm in Glenwood Springs, Colorado, which has a giant hot springs pool. I'm floating in the pool, having family visiting from out of state. And we're all having a grand time. And I look at my phone and I'm starting to get tweets from people saying, hey, Andrew, you need to address this. And this was apparently Nat lawyer chick throwing shade at yours truly, attorney Andrew Branca. So I said, well, maybe I should take a look. I wonder what she's saying about me that everyone is getting so upset about. So I went to look, but I can't see her tweets because she blocked me. So this is the sign of a genuine intellectual coward. They block you and then they talk shit about you from behind the block. Tough She-Hulk lawyering here. So thanks, Natalie. That was always appreciated. So I mentioned this also because I don't have direct access to her tweets, obviously. So other people have sent me her tweets. I don't know if I got all of them that involved me or if it was a select group. I can only respond to the ones I received. But if Natalie would like to clear anything up and have a one-on-one conversation or debate, I'm easy to find. I haven't blocked her. So keep that in mind, Natalie. I am always available to you to talk. These are, you might think that these were two different people. These are supposed to be the same woman. They don't look like the same person to me. The circle, of course, is what she presents in her tweets as her avatar. That's what we're supposed to think she looks like. The other is the photograph that she has in her little bio when you click to look at her account. If this isn't grounds for federal wire fraud charges, I'm not sure what is.
I guess while we're accusing people of crimes, federal wire purchaser.
Clearly misleading.
Okay, so how did this beef start, though? This is
So
where
well,
I'm confused.
it started on your show. So apparently she took offense. We were going through LawTube.
In LawTube. I'm gonna do it. I'm gonna put the dicks on the table.
Whip it out.
Who is your least favorite person?
I don't remember their name. So
Describe their content, and I will tell you their name.
it's racially centric.
Who?
They have a
Racially
racial
centric?
agenda in their content.
Legal Eagle?
He's
No,
not involved.
I don't think so.
Oh, a racial agenda, you said.
Racial is did I stutter?
Male or female?
No,
Female.
it wasn't you. It was
Female?
it's
She said
female. Oh shit, I think I know who it is. Is it Natalie lawyer chick?
That's the one. Yes.
Okay.
Everything is racist all the time.
Yeah, because the law is supposed to divorce itself from racism, right?
Well, we'd like to think so, wouldn't we? That would be appropriate.
My only interaction with her has been on legal analysis on various cases we were covering, particular the Kim Potter case. And there, I found her commentary. She was a guest, as I was, on your show, so we were exchanging dialogue.
Right.
Her legal view of that case, her legal analysis of the case, to be very childish and simplistic, and not something I would expect to come from someone who was a good attorney. The particular issue involved the question of Kim Potter had thought she was deploying a taser on the driver of the car. She actually, of course, deployed her pistol and shot him dead.
Right.
But she thought she had a taser. And the question was, well, was even a taser appropriate on those circumstances? And Natalie's argument was, no, it wasn't appropriate because you're not supposed to use a taser on someone who's operating a vehicle. But it was an open question whether the vehicle was in gear, for example. The reason you don't want to tase someone who's with a car in the driver's seat in gear is that just the shock, the electric shock could push their foot on the gas and the car could speed off. And so definitely if the car's in gear and they're in a position where they could put the vehicle into motion, you may not want to tase them. You're creating risks to the public by doing that risk. But here is an open question whether the car was in gear or not.
Right.
So whether that particular risk of the taser even existed on the facts of this case. And Natalie's position was that, well, no, it doesn't matter whether the car was even running because DUI law, drunk driving law, says you're operating a vehicle even if all you do is put the key in the ignition. And that's true. But this is where the quality of lawyering comes in. There's many terms of art in the law that mean one thing in one legal and factual context and mean something else in a different legal and factual context because the public policy and goals are different for each of them. So having a car operating a vehicle for DWI purposes, the reason just putting the key in the ignition is enough is because it's an obvious, necessary precursor step to driving down the road. And we don't want drunk people driving down the road. So if you're drunk and you're taking those necessary precursor steps to drive down the road, we say you're operating the vehicle. That you're not putting the key in for no reason. You're not putting the key in to then get out of the car and leave it there. You're putting the key in for the purpose of driving the car down the road. But that doesn't apply in the use of force context, because what applies in the use of force context is whether that car is likely to become a missile going down the street. And then it matters whether or not the motor is actually running or the car is in gear. So you can't simply grab the operating a vehicle language from drunk driving law and pull it into use of force law and pretend it has the same application when the underlying issues are completely different. So I thought that's like a first year law student mistake. There
were some issues. I took issues with her analysis too, and I actually take a lot of issues with what I would consider a very pedestrian analysis of the Kim Potter shooting, which was, frankly, from a lot of people, black victim, white cop, therefore racially motivated and guilt. And the problem with Kim Potter and Dante Wright was the name. I had to think back to the white chick who was coding black, chanting Dante Wright. Our people don't have life insurance. Our buildings have life insurance. I had to remember her. That she's such a beautiful thing.
They said buildings don't have life insurance.
Buildings don't have insurance. Y'all see how fast they built that Target back? All the Targets, everything that was built. Fucking you see how they rebuilt Northside? They gonna do it again. They gonna continue to rebuild everything while they continue to kill our people. These buildings have insurance, everything.
Your face. Our people. All the white women getting shot everywhere.
Are you fucking serious?
It gets better than this. So Dante Wright, so he's black, she's white, therefore there's race involved, which there was in this case literally no evidence that there was any racial animus ever. Kim Potter doesn't have a history of racial animus. There wasn't a motion in limine removing some history of racial animus. She had a rather exemplary police record, and all of the evidence boiled down to she thought she was drawing a taser. Like that seems to be very clear. There's no evidence presented that she somehow was hiding the fact that, or that the taser narrative came after or something like that. It was contemporaneous. She yells taser, taser, taser. All of the stuff that she does is consistent with drawing a taser, except for the fact that she pulls her gun and shoots.
Right. Even the state never argued that she knew she had a gun in her hand. In fact, they argued wrongly this should be an appealable issue, but for various reasons, it's unlikely to be. But they argued to the jury that they had no duty. They had no legal obligation to show that she knew she had a gun in her hand, which is bad law. That's a mistake.
Very bad law.
Yep. But even they were not prepared to say that she knew she had a gun in her hand. Nobody made that claim.
Kim Potter's case has a matter of law that was, we'll say, glossed. I'll say glossed due to the actual social narrative surrounding that case. And the matter of law is, can you prosecute someone for a mistake, an accident, for something that has not the requisite intent? And as a matter of law, based on the facts, even the facts in the favor most favorable to the state, I have a hard time saying that Kim Potter is responsible for a murder or a manslaughter in that case, because she did not use the deadly force that in her mind that ended up occurring. She believes she drew a taser and tased this guy. Well, what she pulled was a gun.
That may well have been negligent conduct. You could argue she should have known that it was a taser, not a pistol. That's negligence. That's civil liability. But to get to criminal liability, the conduct has to be reckless. And recklessness requires that you know you are creating the risk, the unjustified risk, and you do it anyway. She did not know she had a gun in her hand. No one ever argued she knew she had a gun in her hand. It can't have been recklessness on those facts. But the prosecution was allowed to misstate recklessness to the jury by the judge. The conviction resulted.
But on that, there's a matter of law, and that's what we've discussed. And she didn't really comment on the matter of law. Instead, she seemed to, in my opinion, she seemed to bring the racial narrative into the factual analysis, and I thought that was improper, personally. And I disagreed with her analysis, but she feels that she is justified by the jury verdict. And I mean, to some extent, she is, right? A jury found her guilty, and that is the way to go. I personally don't think it ever should have gotten to a jury.
Right. Unfortunately, these cases that involve race, there's a certain segment of the community, the legal community, that will just look at them and jump to the racially favored conclusion, which is white officer, black suspect, guilty because of race, because of systemic racism. That, listen, we live in a free country, mostly free country. You got First Amendment rights. You got freedom of whatever opinion you want. It's fine with me. Express whatever opinion you want, but don't call it legal analysis. That's not legal analysis. So this is after she blocked me, by the way. So she's just shit talking now. She's not trying to get any, I guess, not thinking to get a response from me because I won't see these. Maybe she's not aware. People will bring them to my attention. I don't know. But she's shit talking from behind the block. Just saw a video where he, talking about me, says he hates me. Well, that never happened. I mean, this is an outright lie. and says something about her emotional state, because she's not saying that someone told her I said that. She's saying she saw a video in which I said I hate her. Folks, I don't hate anybody, least of all her. I mean, I don't bother hating unimportant people. So this is just an outright lie. So she's starting right off here just with a bald-faced lie. Not a good start, Natalie. Then maybe she goes to correct herself. I don't know. But how would you have seen a video where I said I hate you when that never happened?
I think the closest thing you may have said is that you disagreed with her legal analysis. You probably used stronger language than disagreed, but I don't think hate was ever mentioned. That was very, very weird.
Yeah, I mean, I think her legal analysis is garbage, but I don't hate her.
Right.
What would be the point? Then this came up. Sorry, I'm his least favorite.
There you go.
Somebody must have corrected her. I did say that for sure.
Yeah.
Because I say everything is racial and the law doesn't involve race. Now, it's because she doesn't speak very clearly, so it's difficult to understand what she's trying to get at. I do feel that she brings a very heavy dose of race baiting with her to her views of these trials. That's my perception. I'm entitled to my opinion like everybody else. Go watch her content and feel differently about it if you like. That's up to you. And then she says, I guess she's saying, attributing to me, the law doesn't involve race. And I'm saying the law doesn't involve race. I've never said that. In fact, it's the opposite. My concern is when the law does involve race, when these cases do become racially energized.
Your legal arguments end the moment you enter trial stage. Like
that's why I never predict verdicts.
Right. I thought you did. I read that somewhere.
Did you?
I did. I did.
Another one. So here she's talking about that burger shooting, the video we just watched. She writes, it's so clear that the cop who shot that young man eating a burger was wrong and should be charged with attempted murder. There was no justified use of force. That's not how lawyers approach these questions, folks. Lawyers think to themselves, all right, if I were called to defend this cop, what would my narrative of innocence be? What are the legal doctrines, the legal defenses, consistent with the facts as I know them, that I could raise to knit together a legal defense? You don't just throw up your hands and say, well, the other side's got all the answers. That's not what lawyers do. This is the gut emotional response I would expect from someone who's a normal layperson who sees this. And folks, it's normal when we see a bad outcome to have a negative reaction to it. This is a bad outcome. This should not have happened.
Right.
The Kim Potter taser shooting, bad outcome, should not have happened. The female cop in Dallas who shot the black man in his apartment, bad outcome, should not happen. But that doesn't mean they're crimes. The bad outcome doesn't make it a crime. Whether or not it's a crime is based on legal doctrines and the law applied to the facts of the particular case. Merely having a bad outcome does not decide the question. Obviously, this was a bad outcome and people see the bad outcome and they emotionally respond, this shouldn't have happened. Therefore, someone must be criminally responsible. But that does not follow. And a lawyer, a good lawyer, would know that.
Your initial reaction is one thing. Your legal analysis can be completely different. And realistically, your legal analysis can be colored by your internal thoughts on a thing. And you can try and eliminate and account for them, but it's not always going to work. But it's also fair to call that out. It's also fair to say, hey, I think your analysis is based on these particular facts, which is not good legal analysis.
I mean, anybody can come on and bring an opposing point of view. That often happens, right? Get Nate, the lawyer, on here. He'll have a different view of these cases than I do. Most common thing in the world. I have nothing but great respect for Nate. So lawyers disagreeing shouldn't be shocking or disturbing to anybody. That's what lawyers do. That's water is wet. This is no justified use of force, yet experts, she puts it in scare quotes, presumably that's me, are trying to justify that shooting. I don't justify anything, folks. I do legal analysis. I say this is the argument I would make if I were defending this cop. I care a lot about legal process and argument. I don't particularly care about the outcome. None of these people in these cases are friends of mine or family of mine. It doesn't mean anything personally to me if they get convicted or they get acquitted. But I care about the process. I care about how we get to that decision point. I don't try to justify or not justify anybody's particular conduct. Then she writes, and I thought this is very mirror of her. It could be useful for a little introspection. Natalie, people can get law degrees and still be blinded by prejudice. You don't say. No kidding. I wonder who that might apply to.
People can get law degrees and still be blinded by prejudice. And this, sometimes people say things that apply to themselves.
I think she's talking here about the George Floyd case. I forget what she's referring to as a liar. I think if you didn't believe that George Floyd was murdered, I think you were a liar. Go back and this is another very non-lawyer type of comment. Go back and watch the trial on YouTube. Well, I did actually, Natalie. I watched the entire trial live on YouTube. It's not even up for debate. Why would a lawyer say something's not up for debate? That's rather the whole point of having a trial in the first place, is to debate the issues in the law. She writes, see the face of the EMT who had to move Chauvin off of George Floyd's lifeless body. That was murder. That is not a legal statement. That's an emotional statement. This is a very, very emotional woman. I was going to say young woman, but I saw the other photo, so I'm not sure that would apply. But this is not the statement of an attorney taking an objective, analytical view of a case. What would the face of the EMT have to do with whether or not a murder had been committed?
I do remember a particular set of at least factual assertions, and one of them was that the EMTs arrived roughly two to 2.5 minutes after George Floyd's heart and pulse were no longer, or his pulse was no longer detectable. Right. Which would give even less credibility to the EMT's analysis of what had happened 2.5 minutes before he was even on scene.
There are a few where she gets where she begins to disparage me personally that I do want to address. So I want to make sure we have the opportunity to do that.
Absolutely.
Because I don't want people misled about what I do in a professional context. So let me get rid of the petty ones first. So this is another very mirror comment tweet by Natalie. She should paste this on her bathroom mirror, see it every morning while she's brushing her teeth. She writes, one of the problems with his, I guess meaning mine, legal analysis is that he can't divorce his race and gender prejudice from his analysis of the law and facts. I do real-time legal analysis hundreds of hours at a time when I'm covering these cases with Nick and elsewhere. And if anyone can point out my race and gender prejudice at any point in time during any of that, feel free. But I don't see it. She sees it because it's all she sees. She's wearing race sunglasses. And every problem for Natalie is a race problem. That's how she views the world. Very childish, myopic, and racist view of the world.
But again, the petty part of this is she's not saying that you're a guy who doesn't, who has bad views on women or something. She's saying that it's influencing your analysis of the law and facts, which is weird because, okay, where's the receipt? But what she was saying about your business was completely factually untrue and also legally idiotic.
Yeah, I would argue actionable, except I don't have the time and effort to bother.
But here we go. This is you.
This is me. So I don't know who the rubes are. I guess she means my clients.
I'm a rube.
Okay. The dude, I guess that's me, is ripping them off with his con artist $50 a month program. They're just mad that I said anything. So, folks, this con artist is when you're unlawfully lying to people to rip them off.
That's what I'm doing.
I don't lie to people to rip them off. I'm completely open and upfront. We sell our services. They're all described on our website. If there's a lie in there to justify this claim of me being a con artist, which by the way is a crime, which is defamation per se, Natalie, a lawyer would know that. That's the other thing, to think that someone who presents as an attorney would do something so stupid. It's obviously an emotional outburst, but she's published it on Twitter that I'm a con artist and I rip people off $50 a month at a time. But don't worry, Natalie, I'm not going to go after you over this. It's fine.
I will.
Well, there's a way for people to be basically lawsuit proof, and that is to not have any resources worth taking. And I expect that would be the case here if I bothered to make the effort. So let me explain to people what this whole $50 a month thing is. So at Law Self-Defense, that's good. So at Law Self-Defense, we have tons of content we put out for free. We do YouTube shows most days of the week with free content. We also have members only content, a basic membership where we have the second half of each of our YouTube shows goes private. It's just for our members. It's off of YouTube. That's where we show do video analysis, because YouTube strikes me every time I do video analysis.
Yes.
That's where we do Q&A. So only our members can ask us Q&A on the live shows. There's a variety of benefits, and that membership is just $10 a month, 30 cents a day, not very expensive. On top of that, we have what's called our platinum membership. That's the one that's normally $50 a month. What that gets you is all the benefits of membership normally. Plus, if you're involved in a use of force event, you get my legal consult on your case for free. And my normal retainer for legal consult starts at $10,000, and you get it for free. That's the benefit, and you're guaranteed to have my availability. Folks, don't become a platinum member if you're not interested in that. If you're interested in ensuring that you have me available to consult on your case for free, then maybe consider a platinum membership. But that's the deal. There's nothing hidden here. There's no secrets. By the way, because of this is how we monetize the stupid hate here. Because of Natalie, I've set up a very special offer for those of you in the Ricardo Law community. Normally, it's $500 a year to be a platinum member if you do the annual membership. We set it up for half price for all of you.
Ooh.
You can take advantage of that at lawselfdefense.com/Nick. Get all the benefits of being a platinum member for half the price.
You didn't tell me about this. That's awesome.
Thanks to Natalie. This is all thanks to Natalie. So if you'd like to make your own subtle point to Natalie about how you perceive the utility and value of a platinum membership, my guaranteed expert legal consult, great way to do it and save yourself $250 at the same time is to go to lawofselfdefense.com/Nick. This offer is only good for 24 hours, though. So if you're watching this video, now would be the time to take advantage of that, or shortly thereafter. So that's our platinum membership. And how it works, by the way, folks, is all our platinum members, and we have thousands of platinum members, they get instructions on what to do if they're involved in a use of force event. And that instruction is to have their lawyer call us. We are not representing them. They need local counsel. That local counsel is their lead counsel on the case. Their lawyer calls me to consult on the case. I really only ever speak with their attorney. My client is not them. My client is the lawyer who they've retained. So I'm not providing legal services to lay people out in the community. My legal expert consultation is to another attorney.
And this is how this works. This is not uncommon at all. This is just how this goes. And you hire either expert witnesses or you hire consultants for a case, legal consultants with expertise in a particular area of law. You can hire them all the time. And if you're not standing up and making an argument in court and you're not writing a motion, you don't need a license to practice law in that state.
I don't even need to be an attorney to do what I do. I don't need to be an attorney. I happen to be an attorney. I'm a member of the Bar of the Commonwealth of Massachusetts, but I can do my expert consult. I could just be an academic expert on use of force law, provide expert consulting to attorneys. This is more a commentary that makes me wonder how Natalie even became how can you be an attorney and have this understanding of how being an expert consult to other attorneys works? He's licensed in Massachusetts. Somebody writes, that's correct. I'm a member of the Bar in the Commonwealth of Massachusetts, where I lived for 25 years before moving out to Colorado 5 years ago. Natalie writes, right, yet he says he's an expert on self-defense law in all of the states. Yes, I do say that. Providing legal consultations in all of them. Yes, to other attorneys. Very troubling that this could be unethical. How could it be unethical? It's not unethical in any dimension, folks. Then she writes, business-based in Colorado, but licensed in Maryland. Weird. No, it's not weird. I got admitted to the bar in Massachusetts, lived there for 25 years. 5 years ago, I moved to Colorado. There's no requirement that I change my bar membership when I move from one state to another. I can't lie about it. I don't describe myself as a Colorado lawyer because I'm not admitted to practice law in Colorado. I'm a Massachusetts barred lawyer who happens to live in Colorado. It's the most normal thing in the world. It's so normal that my renewal form for my bar fee every year has a special place for me to put an address if I'm out of state. So it's extremely common.
And by the way,
this Natalie, the lawyer, would not know this is beyond me.
Someone who she appears with on stream quite regularly is a lawyer who is barred in a United States state, but lives in Europe. Like, are they barred in Europe?
How is that possible?
How could it be? Which, by the way, if it's not clear from my sarcastic tone, is not a problem in any way. It all depends on where you are practicing law. If you are practicing law, what I do on YouTube, for example, is not the practice of law. If I move to Nevada for whatever reason, I would still be a Minnesota barred attorney, and I may not try and transfer my license to Nevada. Maybe I would. It depends on what I want to do with it. I could do the same exact thing. And it would have there'd be no need to do that.
If I think she really got stung when I said I liked her least among the law tubers. Here she writes, I had no interest in him before, but since he's talked trash about me, so saying she's my least favorite is now trash talking. I went and looked him up. He's holding himself out as an expert in all 50 states. Yes, I know at least in my state you can't do that. No, you can do that. There are states that say before you can present yourself as a attorney representing clients with a particular expertise, you have to have some kind of certification or take an exam or a certain amount of experience. States vary in this, but certainly those rules exist. And the reason they exist is we're trying to protect the public who's hiring a lawyer from being misled about a lawyer's expertise. Folks, you can't hire me. I'm hired by your attorney. My expert consultation gets filtered through your local attorney, who I presume is qualified to do whatever it is you're hiring to do. That's between you and your attorney. But these laws don't impede my ability to provide expert consultation to other attorneys. They might apply if I was trying to practice law in those states to clients directly, but I don't do that. I don't even know where he's licensed to practice law, but it's not Colorado. No, it's not Colorado. And of course, as we already said, it doesn't matter. So this is kind of redundant, but just for emphasis, she's writing here, how are you going to offer legal consult services for active criminal cases in states you're not licensed to practice law in? We already covered this. A disclaimer that this is a legal consult for the person's attorney when the attorney hasn't consulted with you is a major ethical issue. The attorney called me. The only reason I'm on the case is because the attorney called me, spoke with me, retained me, and mailed me a check. That's why I'm on the case. Nothing is happening independent of that counsel. By the way, what's remarkable too here is this is absolute reckless disregard. So if you go to the link that's on my name here, lawselfdefense.com/Nick, to get that half off on our platinum membership, thanks to Natalie, you'll see an FAQ right on that page that explains all of this. So any questions Natalie had about my professional services, she could have just asked me and I would have told her, or she could just go to our website, click the platinum member link, read the fact, and she would have known all of this. The fact that she's casting these aspersions without even making that modest effort says a lot more about her and her approach to the law than it does about me. So this is the very last one, but I did want to touch on it because it's actually important and substantive. So she says, so people are paying you, I don't know what, she's not talking to me here, but to potentially incriminate themselves. Great idea. So folks, this is could be a real concern. So I want to address this specifically. One of the reasons that we don't want you to call us directly if you're in need of legal services is we're not your attorney. And we want you to tell your story to your attorney where that conversation is privileged. It's protected. If you tell me what happened, that's not privileged because I'm not your attorney. Once you tell your attorney and your attorney calls me to retain me to consult on the case, then I'm covered by his privilege. But I don't want you calling. And if you call my office, if you shoot someone in self-defense or what you think is self-defense, and you call my office and try to tell us what happened, we'll immediately stop you. So you can't talk to us about the details. We have to hear from your attorney first. So yes, if you were just to call and start telling someone who's not your attorney what happened, that's all discoverable by the prosecution and admissible as evidence. And you definitely don't want to be doing that. You could be incriminating yourself. That's why at Law of Self-Defense, Natalie, we don't do that. How do you do that head shake thing?
The first yeah. Oh, no, you didn't.
I can only say in closing that as little as I thought of Natalie as an attorney during that Kim Potter exchange, she's only dug herself even deeper.
Yeah, it's when I read it at first, I was like, what the fuck is she doing? Yo, Natalie, you need to keep Mr. Branca's name out your fucking mouth.